Hello, everyone. Welcome to our live today at Callisto. I am Tracy D. Tomasi. I am the CEO of Callisto, and here we believe in the power of connecting survivors of serial perpetrators. So we built technology that allows survivors to securely and confidentially find others who have been harmed by the same person without having to publicly come forward. And so we know that our current systems can be really, really overwhelming to survivors and often re-traumatizing. And so our tools give survivors a way to safely connect, to process what happened, and to explore their options. Again, whether or not they choose to report. So one option that campus survivors have is to file a report under Title IX. And as many of you know, survivors and advocates have been waiting months and months for the Biden administration to release the new Title IX guidelines, which finally came out last week. So today we are really grateful that Cari Simon has come back to help us understand what these new guidelines are and what it means for campus survivors of sexual assault. So I am going to add Cari.
There you are. Hi, Cari. How are you?
I'm hanging in. How are you?
I am good. Thank you again so much for joining us. And for everybody that's here, I just want to give a content warning. We are going to be talking about sexual assault, not in any detail, just really more solutions to it. But I do want to make sure that we just kind of give our audience that warning. So if you're on today, thank you again for joining, and you've missed our previous live with Cari, you should check it out in our IG Lives highlights. But for those who have missed our previous chat, Cari, can you tell us a little bit about yourself so people know who you are?
Number one, I'm a huge fan of Callisto. Other than that, I'm Cari Simon. I'm a Title IX attorney. I represent survivors of gender-based violence on college campuses in K through 12 and colleges. I get to do that all over the country. I worked for a while on Capitol Hill doing victims' rights policy work, but I really love the direct service element that Title IX lets me do to keep survivors' educations and lives on track. So that is my background.
That is fantastic. So we have a couple of questions already prepared for people joining in. If you want to ask a question, there's the little question bubble on the bottom. So feel free to put them in your questions in there. Also, we have somebody moderating the chat who will grab your questions from the comments as well. But please feel free to ask some questions. We're going to be on here for about a half an hour, so we'll get to as many as possible because I'm sure that there are so many questions. But the first question that we have for you is that I know that the new regulations are, like 1,500 pages, and so I'm sure that you haven't fully gotten through them yet. I know I have not even tried to dig into them, and I'm just relying on your expertise at this point. But can you explain in simple terms what changes have been made to the Title IX guidelines in relationship to SA?
Yeah, so let me repeat what you just said. So the new regulations are 1,561 pages. Only 57 of those pages, which is still a lot, is the actual regulation. The rest is preamble, which is language that the department issued responding to the comments that the public made, and better expanding and giving us some information and background on how they're thinking about those 57 pages that are the end of the document that are the new regulations themselves. So these are coming into, which will now eventually replace the regulations that were put in under the DeVos period when she ran the Department of Education. And those have been in effect since 2020. So it's been a while, and we're now really changing those rules to go, in some ways, to go back to where we were prior to that rule, essentially rescinding a lot of the more stringent parts of that requirement, but also really thinking ahead about how to sort of, in some ways, expand the scope. So there's been some exciting changes in that direction. So with that, I have started to review that document quite a bit and been thinking about it a lot, but I'm certainly am not an expert in it yet. So don't feel like you have to be either if you're on trying to figure out everything that's happening. So just to kind of give that as background. So I think the question was, what is changed for survivors, or what's important in the context of sexual assault?
Yeah, what changes have been made to those guidelines in context of sexual assault?
Yeah, here's the first thing I want to highlight that I'm really excited about. It is bringing back language that's always been my favorite language under Title IX since 2000, regulatory understanding of what Title IX means. And just to remind everyone, Title IX itself is 37 words. So this 15,000 this page word is a new set of interpretations of those 37 words. So And that's just what it means is that we can always interpret Title IX to make sure it's fulfilling its promise of ending sex discrimination in education. So one piece of language that's back that I've always loved and I'm so happy to see is the basic obligation of a school in response to being aware of sex discrimination and sexual assault being a form of sex discrimination, is that once on notice, a school has to take action to promptly and effectively end any sexual harassment and end any sexual harassment and sex discrimination, prevent its reoccurrence, and remedy its effects. Like, that's a lot. Take prompt and effective action, prevent it from happening again, and remedy the impact it's had. Like, so I think a lot of everything else arises from that in my heart. Like, that's where that's my starting place. Okay. So with that, what's in the rest of this long document? So one of the big things it does is change the scope of what counts as sex discrimination. Sexual assault continues to account, but it says it's putting sexual assault in the context of broader sex discrimination more directly by saying sex discrimination can be based on sex stereotypes, sex characteristics, pregnancy or pregnancy-related conditions, sexual orientation, and gender identity. And sex-based harassment is the sort of what we normally call sexual harassment. And then under sexual harassment, that's defined again more broadly than it was under the previous regulations to include that includes sexual assault. I'll talk about that definition later. But the big thing is that this scope has changed from not just being about sexual harassment alone, but looking at like, hey, sexual harassment is part of a broader issue, which is sex-based discrimination. And I think that's a good frame for how we want to be thinking and talking about sexual assault, dating violence, domestic violence, stalking, sexual harassment, pregnancy discrimination. It all lives in the same world and in preventing someone from accessing the benefits of their education. So that's one, scope. Number two is where sexual assault or other type of violence happened or other type of sexual harassment happened. So under the DeVos regulations, it was really explicitly said that if it's outside of a school's program or activity, such as like off campus, that a school had to dismiss it. That's gone. Now, there's, if it's a program activity, then a school, of course, has to respond to it. It also has an obligation to address sex-based hostile environments under its educational program activity that were contributed to by issues that happened off campus. So it's saying if it's affecting you on campus, they have to consider it. So that's one new way off-campus sexual assault is coming in. The other way is they say if you have disciplinary authority over other types of conduct that are happening in other locations, then you have it here too. And that's been something that we've been arguing for a long time. Lots of schools, someone posts a racist chant on their online service, something online, and the school can take action, but they won't for an offline sexual assault. Oh, actually, this happened in many of my cases where a school was taking like authority against a fraternity, for example, for the alcohol that happened at the party, but not the sexual assault. Well, you can imagine how crazy. I definitely sued that school, but now the regulations lay it out for us, right? That you have, if you've got disciplinary authority, that's another hook. So huge difference. Expanded definition, expanded what schools have to do. They have to prevent its reoccurrence, address its effects, and immediately take prompt and effective action. And then it's also off campus. So there's two more big things, but I can stop if you want to.
No, keep going.
Okay, two more big things that have happened that are big in this rule. So the next is the definition that I alluded to before. It's expanded on what counts as sex-based harassment. So what's kept the same is quid pro quo sexual harassment. That's like give me a blowjob for an A. Is the VAWA crimes, sexual assault, dating violence, domestic violence, and stalking. And then the third was a really narrow category. To get in other than that, it had to be really, really bad harassment. Now, here's the new definition, which was historic definition, which is the Title VII definition, which is the one we want for our schools, which is unwelcome sex-based conduct that, based on a totality of the circumstances, subjectively, meaning how I feel, objectively, how someone else sees looking at it, is so severe or pervasive. That's key. So it used to be severe and pervasive. So now it's severe or pervasive. So it happens a lot or it's very bad. Either one gets you in, would be considered sexual harassment. That it limits or denies a person's ability to participate in their education. Under the DeVos rule, it was denies a person's ability. I mean, you couldn't just limit it, you had to deny it. So this is a much more expansive definition that protects a lot more people. So that's really exciting. Okay, last point I wanted to make before I turn it back to you, that we're seeing is a big change. The next thing is, okay, so now we've made it much easier to get in the door. We've have much more obligations on schools. We have expanded the location and expanded the definition. What happens once you report? If you decide to report, what kind of process do you get? And the process has really changed. So under the DeVos regulations, there had to be live hearings and cross-examination. Under the Biden regs, the hearing is optional. A school can choose. So a school is going to pick what their policy is going to be. It can have live hearings. And if under lawsuit, because of like what's happening in courts, some jurisdictions require it, but most don't. So those schools are going to have live hearings anyway. If you don't have that, then the school gets to choose. Do they want to have live hearings or not? Within live hearings, there's two models. One is just like what we see now, which is advisors cross-examining each other's witnesses. The other is you just submit your questions to the decision maker to ask to the other side. That's how it was before the DeVos rules came in. And the third is it can be just an investigation to decision model, where as long as the person who's making the decisions gets to ask questions directly of the party and the others get to submit questions that they want asked, it can all be done basically via a variety of meetings and investigation that ends in a decision. And that's really important because I think a lot of folks have felt that that was a less traumatic process. And so now that's available again to schools. So those are some of the biggies.
And that's so much already. And so thank you so much for sharing all of that. I know that I'm going to have to go back and listen to this just to make sure that I fully take notes and understand it all, but that's really extremely helpful. For people who are just joining us, I'm Tracy D. Tomasi. I am the CEO of Callisto. I have Cari Simon here, who is a Title IX attorney, joining us live today. We are going to be talking about sexual assault in some capacity, so just want to offer a content warning with that. And if you have questions for Cari, please make sure to submit them in the little question bubble or put them in the comments, and we have somebody moderating the chat to be able to pull those questions as well. So the next question I have for you, Cari, is that what does the rules say about repeat perpetrators on campuses? Because obviously at Callisto, we are really focused on those serial perpetrators. We know that 90% of sexual assaults on college campuses in the US are committed by serial perpetrators who on average offend 6 times, which is the whole basis of why we exist. So tell us what the rule says about repeat perpetrators on campuses.
Thank you for asking that. So I'm in my work, I representing survivors through campus disciplinary proceedings. In about half of my cases, there are other victims of the same perpetrator that come out in a variety of fashions, whether they also reported, whether you hear it through the grapevine, or someone has been, or you just hear it because you talk to somebody on a park bench, describe what happened and find out the same person did it to them. It is so common. And then Callisto has made it really even more accessible to find those other victims and allow people to come forward together. But schools, in my experience, have had mixed approaches to how to address that, whether they want to consider it or they want to ignore it, is like sort of the ends of the spectrum. And then somewhere in between, not really knowing what to do. So I want to tell you about two things, and I want to direct everyone to who wants to read these regs. I'm happy to have share exactly where to find them. I think this is on page 147 of the new regs. No, 714. Okay, so it has two parts. So the way that this preamble is written, what you'll see is first, the department talking about the comments they received about the draft regulation they put out many months ago, and then telling you what they decided to do with that information. So it starts with comments that I know your organization and I submitted to them where they talk about it. So I'm going to read to us a little, bear with me. Mm-hmm. So it says, some commenters like you and me, and probably everybody on this call, asked the department to expressly permit pattern evidence of the respondent, that's the person who's been reported, of their sex-based conduct as pattern evidence of their prior sexual misconduct, and to weigh that based on its strength. And then they cited, those who said that, cited prior, let me just read this because I'm going to get it exactly right. So they talked about how other rules like state evidentiary rules, Title IX, and the Clery Act all allow for this, how we need to address the frequency of repeat perpetrators and the small likelihood of survivors of repeat perpetrators will report because of underreporting and like needing to move forward when then there's patterns. So, and then they address like this issue that you raised around like this being a really important place because there's so much sexual harassment that is committed by few. So the department said, we hear you. We appreciate your current concerns raised where sexual harassment or assaults by the same respondent have occurred. They said, we're declining to write directly into the rule to say that Oh, sorry, this is not what they said. I'm getting to two parts. There was two parts. So first, the people said, we want like the rape shield statute to apply to those victims too. The department said, we're not doing that. We're not like adding
Can you explain
to.
what that means a little bit?
Yeah, so rape shield means is something that's been around for a while now in lots of justice systems that says you can't bring the sexual history of a victim into a case to try to prove anything. It's irrelevant. Even if it's relevant, we're not considering it. So it's like making the shield, which is just a part of the history of calling sexual assault survivors sluts as a method to
I
discredit
mean,
them.
today is denim day, which is why I've got my denim
You got
jacket,
it. You
which
got
came
it.
from wearing too tight of jeans and a perpetrator getting, not being held accountable because the jeans were too tight. So
Yes, exactly. Oh my God, terrible. Okay, so here's the exciting part. It says that we, while we're not going to expressly permit it, they say that's because it would already be relevant if it's relevant. So they said, so this is just important because it's never been said in the rules before. So already everything that's relevant has to come in. That's like just the basic rule of Title IX proceedings and most proceedings. So they're saying that, this is pattern evidence is governed by the relevance standard, and relevance is, does it make a fact more likely or less likely? That's how it's considered admissible, just like any other proceeding. And so it says the quote pattern evidence may be permissible for use under Title IX grievance procedures, as the recipient, the educational entity must objectively evaluate pattern evidence to the extent it is relevant. So that's all I ever wanted, was them to consider it, have to consider it. So I think this is transformative, this language, that is giving us some legs for the first time in Title IX regulations to really tell schools you have to evaluate this for its relevancy. And pattern evidence is just like any other piece of evidence. So that is my exciting news. I'm happy to, if that was too lawyerly, I'm happy to unlawyer it. You tell me.
let's unlawyer it, because I think that that's really important, especially when people aren't lawyers. We have a definitely different understanding of that, and people in
Yes.
trauma don't always process things the same.
Yes.
And so definitely explain it in the simplest terms possible, because I think that this is a huge impact as to why we've been doing the work that we're doing, and the impact that Callisto can really have in holding perpetrators accountable if survivors choose to report.
Okay. So let's talk about it in practice. Prior to this language, I would represent a survivor through a disciplinary proceeding. There'd be a second victim. We would say, interview the second victim. They're happy to, or we'd submit a statement from the second victim of the same perpetrator describing similar conduct. Some schools would say, thank you for this information, evaluate it, and consider it as part of the evidence. Just like there's also evidence of the text message I sent the next day to the perpetrator saying, like, why did you do that, right? That's evidence. So is pattern evidence. That's just another form of evidence that's showing something's more likely than not. That someone did the same thing to somebody else in a similar way. It can show have a similar motive. It can show a lack of mistake. It can show just a pattern of behavior that makes something more or less likely to be true. So some schools allowed me and my client to offer that as evidence. Others would just white it out, right? We put out a report, we give them the information, and then they would just white it out. They would just, pretend it wasn't there. And it was just a mix at every single school. You just didn't know how a school was going to respond. They would say, Miss Simon, we're only looking at the evidence of your client's case.
Right.
And I said, no, this is pattern evidence to show my client is telling the truth. I'm not asking you anything but to include more information that adds to the overall thing. So some schools were really resistant to this idea of considering pattern evidence in a single case. Just to remind everybody, this is the way the criminal justice system works. You consider pattern evidence. Same with the Title VII system. Same with civil, if you sue civilly. All of those include other victims that show a pattern. But Title IX, it just was the rule. The DeVos rule and every rule before said relevant information had to exist, but it didn't talk about the nuance of pattern evidence. So that left somewhat of a void for many schools to say, well, I don't know if it doesn't seem relevant to me. And so the idea that pattern evidence could ever be relevant was something they were resistant to. Some schools were not silent in their policy already. So some schools' policy, your school right now, Brown University, says, we consider pattern evidence. Michigan says we consider pattern evidence. If it's substantially similar, we'll consider it. But many schools just whited it out. So, myself and the folks at Callisto asked the department, when you're issuing this new regulation, can you please just explain to people that pattern evidence is relevant evidence just like anybody else and should be evaluated like anything else? Now, the regulations say that a school must evaluate pattern evidence. They have to consider it. They have to evaluate it, whether it's similar or not, and how much it's relevant to a certain case. Like, they have to consider that evidence rather than just whiting it out. So now, when a new client that where this rule is in effect comes to me and they say, my friend was assaulted too. She doesn't want her own case, but she just really wants to be a witness in mine. I'll tell you, so many victims are happy to do that, right? That is a place where I often talk to a second victim, like, I really don't have it in me to do my own case, but I really want to support her case. That's a true heart of many survivors. Now, when I go to the school and say, here's this other piece of information, they are not permitted just to white it out. They have to consider it evidence like anything else. And I will point them to this page and I will tell them the Department of Education has already said so. Here it is. So whereas before it was like hit or miss on what a school would do, many didn't know how to handle it and many resisted. Now it's at the forefront where it's clear that this is something they have to consider.
And that's just huge. And that, because we know that it matters, which is why we exist. That's what, it's why Me Too is so powerful, is because we know that these perpetrators, these repeat perpetrators are out there, and we can hold them accountable so they stop doing it. And that will prevent so many sexual assaults. Yes. So thank you so much for explaining that in both ways, the lawyer way and the non-lawyer way. So if you're just joining us, I'm Tracy. I am the CEO of Callisto. We have Cari Simon here, who is a Title IX attorney and explaining the new Title IX guidelines. Content warning for those here, we are talking about sexual assault, nothing in detail, but as it relates to Title IX. And if you have questions, we've got about 8 minutes left, so I'm not sure we're going to have time to get to too many, but please put them in the chat or put them in the little question box. So the last question we have for you, Cari, is when do these guidelines go into effect, and will they impact people who have already experienced sexual assault before these regulations went into place?
Really important question. They go into effect on August 1st, 2024. It is not retroactive. So it's by the time of the incident. For any incident of sexual assault, sexual harassment, sex discrimination that occurs before August 1st, it's stuck under the DeVos regulations. For any instance that happens on August 1st or after, it will be under these new regulations. So
it's not about reporting when you report, it's about
correct.
When the incident
So
happens.
It's not like you can be like, I should wait to report until August 2nd. That doesn't do it. That will definitely be considered under the old regulations about the date of the incident, August 1st forward. So right now, schools have 3 months basically to revise all their proceedings to be ready for August 1st. So essentially it's for the new school year that this will be the rule that, like, all schools are creating their policies to be in line with this regulation, which is another point I think is good to talk about right now. For those of you that are doing advocacy on your campus, I've already mentioned a few places where there's discretion for schools to decide, what if they want to have hearings or not, for example. They're making those decisions right now. So this is the moment where all the places that there are discretion in this rule for you to express what you want your school to do.
Great. Thank you for explaining all of that. So, we have the regulations in, it's still a couple more months, but we're getting there.
Yes.
The question that we got before we did this was that somebody really wanted your thoughts on the drawbacks and or concerns with any of the new regulations that could lead to potential roadblocks to survivors reporting. Have you noticed any so far? Again, I know you still have to digest a lot of things.
Yeah, that's a great question. I think that there is still things that survivors wanted out of the DeVos regs, and I'm going to use a really small example. When a perpetrator or respondent gets notice, that notice will have a sentence that says there is, oh gosh, why am I losing it in my mind? That there's no presumption that there's a presumption against that they're responsible for what they did. Versus what a lot of us thought was that because instead of like the criminal system where they have these constitutional rights, we have equal rights, there could be a presumption both ways. We don't presume one way or the other, right? Like right now, we're not presuming you did and we're not presuming you didn't. We're making no presumption one way or the other. I'm just giving you that as an example that someone might feel icky about. I don't know if that's full on roadblock, but I'm just using it as a small example to say, there's plenty of that in there. I don't think this is, to the extent folks feel like live hearings is chills reportings or makes someone not want to go through the process, this permits schools to have that as process. So, to the extent that schools keep that and survivors find it to be a process that they decline to participate in for that reason only, then the rule isn't helping in that way. It's giving schools a lot of discretion. And that's why I'm trying to emphasize that this, and maybe we can do a different IG live on that this period, these 9 months is a moment where we need to be having our top 5 things that we're asking our schools to use their discretion in a certain way to make it a better place. So I think this is actually an empowering moment to give input. Things are changing right now in response to this. There's a lot of discretion. It's a great moment for input.
That's a great point, that if you are at a school, it is a good time for you to pressure your school into using the discretion that they have in good ways. And so I'm sure that, you can reach out to us. We can put you in contact with Cari. Cari, I think you're willing to let us share your email address if people have questions, if people need a lawyer in the Title IX realm. I know we have about 5 minutes left. So, and again, this has just always been so eye-opening every time we talk to you, and it's been really helpful. But before we wrap up, is there anything that we haven't talked about yet that you think it would be helpful for survivors to know about these new guidelines or Title IX in general?
I think the other piece I haven't talked about, and mostly because I haven't digested this part of the regulation that much, is that, and it's something everyone should just know about Title IX generally, is that it also requires that schools give survivors supportive measures to protect their education that remedy the impact of sexual harassment and sexual assault on their education. So if someone doesn't come forward for a year and they have a lot of problems on their transcript that result from that Title IX gives them rights to have that addressed. And also looking ahead, like if they need extensions or they need to move houses, like there's a whole lot of things that survivors need to feel safe on their campuses. And this rule also has language in that to make sure those are robust. I haven't done enough to know how much those are better than where they were before. So I didn't talk about it much here, but it's still there and you absolutely have that right. One thing I know it does that's more, I think, direct than it was historically is to say that you don't have to go through a full process to get these. That's not required. And I think that's something we want to tell survivors every day is like the thing you need is to just have your schedule changed. That can happen. Like you don't have to go through a whole process to have a dorm change.
Right. That's really great because I don't think a lot of people know that there's like a lot of accessibility things that
Yes.
This can help without having to go through the whole process, which is really great. So, and with that, we did have, again, remind people that there is an IG Live that we did last year in our IG Reels. So if you look at that on our Instagram page, if you're not following us, follow us at Callisto and check out our website, projectcallisto.org. For further information. If you have a .edu email address, you have free access to Callisto Vault, where you can put in a unique identifier of the perpetrator, such as their Instagram handle, their social media handle, email address, phone number. Somebody else puts in that same identifier, there is a match, and then we connect you with a legal options counselor. And that again, that pattern evidence that Cari just talked about can really strengthen that. If you've already reported to Title IX or the police, you can still use Callisto Vault. If you haven't, you don't have to. We don't pressure survivors. We make sure that survivors are always in the driver's seat. Cari, it's always a pleasure talking to you. If you want to share anything else about the work that you do or how to contact you, please do so.
Sure. I represent survivors every day and I try to fight hard for them. You can reach me directly. I'm also happy to chat with you about what's happening at your school, or if you're a survivor in need of assistance through a disciplinary process, that's what I do. You can reach me by email at csimon@tfnlgroup.com. That's csimon@tfnlgroup.com. So feel free to reach out anytime. I'd be happy to talk to anyone here on this call or anyone who watches this. Anyone who's supporting Callisto, I support too.
Fantastic. And if you didn't get that, DM us. We'll send it to you as well. And so thank you so much. We'll have this recording up soon. And if you have ideas for questions for us to talk to Cari about on another live in the future, please let us know because we always know that she's happy to come back and we are always happy to have her. So Cari, thank you so much. Enjoy the rest of your day. And thank you everybody for tuning in.
Thank you.
Bye.
Bye-bye now.